You can't stop them from asking their questions. Colleagues, good afternoon. We want to start by reacting to a number of comments that have been made by the spokespersons for the petitioners' legal team, and then we will deal with our summary of what has happened. I'm sure you have all followed, and so we don't need to even spend so much time on that one. Our colleagues who speak for the petitioner started off by telling you this afternoon that they are of the view that the Supreme Court of the Republic of Ghana is wrong in law, at the ruling that it has delivered this morning. They also claim that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda. I'm sure you heard the words used by Dr. Ayine, that the Supreme Court has reduced the petition to a single issue petition, and that smacks of a predetermined agenda, ostensibly not to rule in favor of the petitioner. Now, we want to deal with those first two. While dealing with a third matter, they keep bandying this word about truth. What is the truth? And that the truth must be allowed to come out. We'll deal with the question of truth as they talk about it. And then this claim that the Supreme Court is shielding the EC chair from getting into the box. In fact, in Chi, they make the argument that the Supreme Court doesn't want to allow the EC chair to give testimony. We'll deal with all of those before we come to our submissions. And then they make the argument that they are doing this for the people of Ghana and in the defense of the Constitution. We honestly don't think that is true. We'll deal with that one. First, let's deal with the issue of the court being wrong in law. This is the Supreme Court of the Republic of Ghana, a bench of 7 justices. And I think on about 2 occasions, 2 others have come to join them to review some of the applications before them. Except for the application for leave to amend the original petition, it is true that all the applications that have come before this court have fallen flat. But how can it be that the petitioner's communication team now argues that the 7 justices or the 9 justices are always wrong in law, and only Mr. Chachuchikata is the one who understands the law, knows the law, and is therefore always right? It cannot be. The last time they won some arguments that some of their paragraphs of Mr. Rojo Metununu's witness statement should not be struck out, you heard them right before you that it was a monumental victory. Are those not the words that they used? And we keep making the point that it is not fair to the judicial system, it's not fair to our democracy, it's not fair to the people of Ghana that when you lose an application because it is not grounded in law or because you have failed to meet the legal standards, then you come here and literally poison the minds of the public and make claims that they may be having a predetermined agenda. That's scandalous of the courts. It's scandalous of the courts. When you make a legal argument and it is upheld, that one is good. When you make an argument and it doesn't meet the threshold, then it means that they are wrong in law or that they have a predetermined agenda. The Supreme Court has not reduced the petition to a single issue. We tried our best to transcribe the ruling. We are waiting for the written version of it. The court said that the major issue, it didn't say there was a single issue before it. It said the major issue. And time again, colleagues, we have read out to you the 5 issues that the court is seeking to determine. And the court says that the major one, and I believe in the minds of every well-meaning Ghanaian who has been following, and I indeed heard it from your questions, the major issue, you forget what they said earlier that they had won. The major issue they brought to court was that nobody had crossed the 50% threshold. And everybody's been looking forward to them adducing evidence to prove this. They have been trying in the last 1.5 weeks to shift it to a new constitutional accountability argument. And the court reminded us the last time that you came here under Article 64(1). The court today has said that the major issue, why do you then decide to mislead the public that the court has reduced the petition to a single issue petition? I think it is very unfortunate, and we must start off by correcting some of these issues. Now, they talk about the truth, and that the truth must come out. The truth must come out. What is the truth? The truth is what the EC chair has declared as at now, that Nana Addo Dankwa Akufo-Addo validly elected because he got more than 50% of valid votes cast. The truth is what is backed by the results of the 38,000 polling stations, or the 275 constituencies, or the 16 regions, which anytime we give them a calculator to calculate, they get 47% for Mr. John Dramani Mahama, 51.2% for Nana Addo Dankwa Akufo-Addo. That is the truth. If you come to court claiming that there is another truth, you have to lay it before the court. So where is the truth that you say you want to lay before the court? You remember when the court asked them, they said they had left their truth at home. They did not bring their truth to court. So which truth is the court supposed to look at? The presumption of regularity is before the court, and you say there's another truth. Where is it? And you say you won't bring it, and that the EC chair must be compelled to get into the box so that you can conduct some surgery and explore the truth out of her. We are not being fair to the people of Ghana if we continue to change the goalpost at every hearing. Now, they continue to make this argument that the Supreme Court is shielding the EC chair or preventing her from getting into the box. The court has said over and over again, and we hope that our colleagues on the other side will pay attention to what the court is saying. The court has said that you cannot compel her to get into the box. She will elect. Indeed, your own argument earlier was that she had elected to get into the box. And the court, after listening to the argument, showed that no election had taken place. So that argument falls flat on its face. Why do you now come and tell the people of Ghana that the Supreme Court is shielding her and preventing her from getting into the box? Because she is somebody or a party who you have brought to court. And the rules settled from the beginning that you cannot compel her. Whether you come by subpoena or you come by any other instrument, you cannot compel her. This argument, therefore, that the Supreme Court is shielding her is one that, again, our colleagues in the media, I think you have to be very quick to call out and let the public know is not true. That is not what has happened. They are the ones who objected to the closure of the case of the first respondent without putting her in the box. They objected. Why? Because they said she owes constitutional accountability. And the court has said that you haven't provided any authority or any law to show us that she should be treated with a different set of rules. Why do you misinterpret that to the public, that the court is shielding her? We think that these things should be called out. Now, there are two paragraphs in the affidavits that were before the court today that I want to read out to you. And I beg you to pay attention to this. This is the affidavit of Mr. John Dramani Mahama in support of the motion to reopen his case. Remember, we kept saying to you in the beginning that it was becoming obvious that they have not succeeded in making any case before the court. And that what they have put together before the court, 30 out of 35 paragraphs, are complaints about the declaration. It doesn't attack the validity of the election or the validity of the results whatsoever. And they said what we were saying was not correct. And we said, bring your witnesses to come and prove it. 3 witnesses they brought could not prove it. And when the Supreme Court heard them announce that they have closed their case, and the first respondent said, I will not get into the box to adduce any further evidence, determine this matter on the evidence that they have brought before you. And we said same. They objected and said they wanted to bring her in. The court ruled on the 11th of February, the law does not support that position. Then they have come with an application to reopen their case. Now listen to paragraph 20 of that application and that affidavit supporting the application. It says that this witness has a unique role under the Constitution in respect of the presidential election that took place in Ghana on the 7th of December 2020. And having her testify is critical to this court. What Mr. Mahama and his lawyers are telling the court that they themselves don't believe that they have made a case before this court, and that if this EC chair is not compelled to get into the box, their case is collapsing. That is what they are admitting by paragraph 20 of their own affidavit, Mr. Mahama's application, Mr. Mahama's affidavit to support the application that they made. That if this witness does not get into the box, or if this person, this party, is not compelled, dragged into the box to testify for them, They have not succeeded. But if you've made a case, why are you begging the court, going up and down, misleading the public that if this person is not brought into the court, you cannot make a case? I thought they said initially they had won, or that nobody won, and that they had 5 witnesses who are going to prove it. They are now telling the court that if the court does not compel Jean Mensah to give evidence on their behalf, and yesterday you heard that they want to call her as their witness and they will treat her as an adverse witness. And by the way, the court explained today that that argument is not sustainable in law. It falls flat on its face. There's no legal position to back it. They are now saying that if she is not compelled, they can't make a case. Now, when yesterday the learned Akoto Ampao, in paragraph 12 of the affidavit supporting our position, said that the instant application does not raise any new matter of relevance which could not have been discovered by diligent effort and does not warrant the grant of leave to petitioner to reopen his case. They said this was irrelevant. And today you heard the court essentially going back to these arguments and the authorities that we had raised to come to a ruling that the position of the law is settled, that you cannot compel a party to get into the box to testify. So it is not about truth, some truth which you say you have left at home, and you are asking the court to drag the EC chair into the box so that you can conduct some surgery on her and find the truth out of her. It is about a legal argument of whether or not she can be compelled into the box to give evidence. And indeed, if you have some truth, why don't you lay it before the court? Now, colleagues, we heard you argue that, or we heard you question, that now some of their own supporters are saying that perhaps they should withdraw at this point. And indeed, it is our view that Dr. Ines skated around the issue, didn't respond to the question. Says he leaves it to the judgment or the conscience of people. Why are NDC supporters now saying they should withdraw? Because they are observing before their very eyes, as this thing is televised live on TV, that their petitioner and their lawyers are not making a convincing case before the court. What they told them is not true. And that is why now they are asking the court to reopen their case so that they can put a party on the other side in the box and compel her to testify to make their case. It's becoming clear right before your very eyes that this is the reason for which their own supporters are telling them that it is about time that they abandon their case. But we want to conclude by dealing with this argument they make that they are doing this for the people of Ghana and they are doing this in defense of the Constitution. We vehemently disagree. What they are doing, this so-called petition before the court, is not for the people of Ghana or in defense of the Constitution. It is for the political interest of Mr. John Dramani Mahama, who desires this media spectacle to sustain his brand equity and run again unopposed in the NDC in 2024. Let's be honest about it. It's not in defense of any constitution, because if it was, the Constitution says that our legal system is adversarial, and therefore you can't compel a party in the box. Why would you be claiming you are defending the Constitution and asking the Supreme Court to turn the Constitution upside down? Those arguments don't hold the test of time. Today, the court has reaffirmed the decision it made on the 11th of February, that you cannot masquerade the same application in a different dress and expect it to do that which the law does not allow it to do. We'll take your questions.
Right. Honorable, good afternoon.
Good afternoon.
So, on several occasions, whilst addressing us, you have referred to the fact that the petitioner also appears to be panning towards public opinion and saying things out of court just to win public sympathy. Unless the second respondent doesn't believe that public opinion is important, I'd like to find out from you. First of all, there was an application for interrogatories. It was dismissed. In the public opinion, it was the fact that the EC, the second respondent, the first respondent, I beg your pardon, has something to hide. Then there was another application to allow the petitioner to inspect some documents. Again, your counsel opposed to that. What went out in the public domain was that there was something to hide, and that is why you were opposed to it. Now there's a refusal to present witnesses.
A refusal to compel.
Well, first of all, your side said you chose not to present the witnesses. Again, the opinion out there is that then it means there is something to hide. If there is nothing to hide, and if the public opinion is also that important, why don't you just open up?
Well, we have said over and over again that this is a court of law, not the court of public opinion. What our colleagues on the other side do is that they come to court and they make arguments that, according to the Supreme Court, these are not my words, according to the Supreme Court, are not backed by law. The Supreme Court has said on about 3 occasions that we don't know any law that supports what you are telling us. In fact, 2 days ago, they asked that this application you have brought, what's the legal basis? So we are praying to the inherent jurisdiction of the Supreme Court. There are times when they cite cases, early stomach law, the court says it doesn't apply. Several times they end up speaking at length, and the court says that the law doesn't support the grammar you are speaking. These are not my words. It's the position of the court. Then they come here and they spin the story to create a different public opinion, that the interrogatories are not being up. And you heard Dr. Ayine repeatedly say that the interrogatories were not allowed because the court claimed that CI 47 doesn't apply. We challenge him. The court never said that. Get a copy of the certified ruling and read it. The court has never said CI 47 doesn't apply. The Supreme Court holds all the powers of the courts beneath up to the Supreme Court and has been using CI 47. CI 99 applies to the procedure in here, but some of the basic powers in CI 47 or as amended 87, etc., they all apply. And the Supreme Court, in using CI 47, said to allow interrogatories, they must be relevant. The question is a question of relevancy. If you come and you ask irrelevant questions painted as interrogatories, the court will not say that just because interrogatories are allowed, it should grant you those when the questions hidden in that box are irrelevant. And you heard His Lordship the Chief Justice said that this your application falls flat on the grounds of relevancy. So if you come and you poison the public mind that they didn't allow it because they have something to hide, you are not talking law, you are talking propaganda. If you come and you say if they have nothing to hide, why are they not allowing us to inspect the documents? You are not talking law, you are talking propaganda. Because to be granted leave to inspect, you must meet a certain legal... But why don't you want to meet the legal standards? Why don't you want to make a convincing legal argument? Do research, back it with authorities. You heard us yesterday, quote authority of authority, Poku versus Poku, Berema, all of these ones quoted. Today you heard the court even adducing some of those to back it. You don't want to come with arguments and legal basis and with propaganda arguments to the public. Why do you want to tell the public that somebody can be compelled? When indeed that's not the position of the law. These are not my words. This is what the Supreme Court is saying. So the court of public opinion matters. But you, our colleagues in the media, we won't fight with you. We won't say you are not being fair to us or argue with you like that. In fact, we apologize on their behalf to you for what they did. But you have a responsibility to help educate the Ghanaian public that what the people are saying is not law, it's grammar and propaganda. Because there are legal standards that must be met. And the court has been, in fact, today, let me just go on one small tangent. If you notice, the court for the first time set out the parameters for determining when you can grant leave to reopen case at the Supreme Court. Any impact on results, obtainable by due diligence, the materiality question, importance of integrity of the process, prejudice, miscarriage of justice. They have laid down about 4 or 5 principles today before you and I this afternoon. This is law, not grammar. So when courts below are now looking at this matter, this is what they will apply to. We pray you to also take an opportunity to help us educate the public so that people don't go telling them stories. Because if that was the case, we have hinted you twice or thrice that, listen, if an argument can be made for a party to be compelled, i.e. the EC can be compelled, then it means that John Mahama can be compelled. Not so. So we should stop the legal work and now make an argument that, okay, we are come to compel John Mahama, we are come to compel John Mahama. We provoke thinking by throwing some of these things out. But just to answer your question, the court of public opinion matters, but you have to help us to educate the public so that people don't throw propaganda out there. Yes, sir.
What does it hurt, whether in law or in the court of public opinion, if the returning officer for the December 2020 presidential election, Madam Jean Mensah, takes the stand? Again, we still are not clear what direction the court is going to go on Thursday. So question is whether you are still going ahead to file your addresses or you are waiting on the new processes that we have just been notified of to see how that goes.
Sixtus, I'll deal with the second one first and I'll come to the first question. So you heard at the end of the proceedings today, Mr. Chikata announced that they will be applying for 2 reviews. The review of the February 11 decision and the review of this decision as delivered. And that they have filed, initially that's what he said, they have filed in the last 20 minutes or half hour. And the bench asked, have you filed or you are filing? And then later he changed, he said, we're in the process of filing. I believe it should have been filed by now. Indeed, for those of you who are in court, when the bench sat and started reading out the decision of the court, then one of their lawyers with the documents got out, even before the ruling was completed. You saw it in court. And you can tell your viewers and listeners whether what I'm saying is true or not. Stepped out to go and start filing the process.
We saw somebody walk out of the court. We don't know where the person
He's the one who went to file it. It's a matter of public record. But here's the point. The exchanges between the bench and the bar was to the effect that, so what happens to the submission of addresses on Thursday? And His Lordship, the Chief Justice, says that our orders still stand. So those orders we understand that we should respect. And he said that if the court is seized with it and the registrar has given a date for it to be heard before then, this court will come back and hear it. And we'll be here also to make our views known on that. Your first question was about what does it hurt? It turns the Constitution of Ghana upside down. It turns the adversarial system of law, which is in our Constitution, upside down. It compromises the time-tested, laid down procedure for adjudication in our courts, which is that when you allege, you prove. That when you tell the court that you have closed your case, you must have some extraordinary circumstances to demonstrate to the court before it will grant leave for it to be reopened. When you don't do that, you don't come, excuse my point, with the propaganda argument of, oh, but what does it hurt? It hurts the Constitution, it hurts the law, it hurts justice. We are here for justice. We are here defending every single vote that the 13 million people cast. Those who voted for Nana Akufo-Addo and those who voted against Nana Akufo-Addo. We are defending all of those votes. If you say that those numbers are not correct, why don't you want to take the responsibility to come to the court and say, these are the numbers that show that this one is not correct? And you say that it is critical to compel Jim Mensah to get into the box so that you can make him the case. Or you can make your case. In 2013, Dr. Afarijan entered the box, not because he was compelled by subpoena. Dr. Afarijan entered the box because the brilliance of Alhaji Dr. Mahmoud Baumia in demonstrating 11,000 pink sheets and the problems with it compelled Dr. Afarijan that if he did not get into the box, the job that he had done was going to be set aside. There's a major difference between these two cases.
So you're giving us a duty to go and educate the public that this is a court of law and not, for grammar. Now, the ruling of the court today would mean to say somebody who just voted, a first-time voter, that the chairperson has, answered questions on behalf of the commission. And
sorry, I'm sorry, I can't hear you. Well, you're saying that the ruling of the court today is
yes, that... It suggests to say that once Madam Jean Mensah answered in the response, then it means that the commission has answered. So the understanding they are going to get is that Jim Mensah is the Electoral Commission.
Go ahead, I'm listening.
And so in that case, how then do I go and convince somebody who just voted for the first time that this is, the court is not shielding the chairperson of the Electoral Commission, but rather is making sure that the vote they cast is protected?
Because somebody came to court with an application that the numbers or the declaration that I hereby declare that Nana Danko Akufo-Addo was validly elected and is therefore president-elect. Somebody came to court saying that declaration is not correct. That person is refusing to give evidence to prove it. He's brought 3 witnesses, and now he's saying that his witnesses didn't do a good enough job. And until they drag the EC box into the chair, he can't make his case. And the court is saying that that flies against the Constitution, it flies against the adversarial system, it flies against the system of law we practice in this country. It has nothing to do about or to do with the EC chair answering questions. If you want the EC chair to answer questions, we can invite her to Parliament. There's a whole constitutional provision for parliamentary inquiry. But the forum that you have chosen and the constitutional provision you have invoked, Article 64(1), is not the platform for general constitutional accountability. Are there any questions, my colleagues? Thank you very much.
Abusanfo ni adehia anembo ha yebeda mo ase enenso eyeda etoso edunsia yehia ewo ha na ansa na no metre sene da ya ne mo ye adwuma no efe adwuma ansantrofo mo ye ne eye enti mi nso magina afidie so na mapa mwacho ye nuanum NDC fo omo nsam en omo kasa tietia mo ne ntoko omo ne moko mubisa asema na akwese abufuo na nsem omo kana kwa kasa twitwe ne mesre ye ne ma na ye adwuma yi enti no mamo mfa eye hwansena ho ahi na mo kwabre mu kuro ya pa acho ma ye nuanum NDC fo omo kasa na munye hwam na munye kra na ye sai atoa so biema ene asema ye ba wo ha sei no ehu behia opani Dr. Ayene Mr. Kasa eno be kasa ye e kam yakwa se ye ka ni egu eye Supreme Court mpanifo hu fi no enye ahu hia ye pa sanse wodi wasem eba Supreme Court a gidi a wo nyina ne se ahwene ti won pani anim a ebi nyira edisa wodi wasem ba pani anim pani ni ka asem na asa ba abonten na wodi kasa twitwe kasa emunye de kasa huntie na wodi ba na wo kasa nokura Ghana fo peso mu huno ayem panifo yi a mo Supreme Court yi epese omo kasa aya kasa enye kasa ebu court animtia enti Dr. Ayene mesre baby wo bia mi se wotia on pacho enye kasa eye kwa na wo sa ka biem se ene Supreme Court nsem omo kan ye no so no emma pepepe yo atentenie omo sinitrase na mra no omo afa no madu mra ni komu a eye kasa enye papa na biem mo san kasa enye Supreme Court mpanifoi omo asan ehye eye Madam Jane Mensanchi ena mo kanisie ena ase omo peso be kasa enye kasa efe kra abusuya senka ye kan bi panke nei o senka dwumadi a ye di wo Supreme Court onfa na ni breso nanka onfa no se eya asem ehu hia sempo yesi opani mahama court oba ye obama Ghana fo enso ye hia court dem a empredunsia emu mienu pe no aba emu du nan no omaye nanso no ono yenka se ana yenka bibia mfentia no asambe na aba abusuafo asama aba ne se Ghana ha ye mra ne kire wa wo bokwa edu no ona ade ho adansidie ba ye Evidence Act section 1417 ekire ana wo konso anya adansidie keke adansidie mu oduo etisa wo court na wo bo nkro wie wo kan wa asem nyina wie na wa wo de to court anim se wo nsem a waka no wani age ho ye pa enti no wa asem no wo bo nkro wie watopunum na court so de nano asem atoso na court nano asem toso wi a na anoyifo no so aye respondent no omo so di omo no asem aba na wei adansifo amofra omo ne nsem a mo kan wo court nyina no na ensisi so na enyina mra so na nya nsem a awose aye anoyifo no omo sai omo daje enu ti ensem a court kan ne se sempo upesa wodi ahoma eso aye maami Jane Mensa kon na obegina adakam na wodi adanse a emra ne nkyesa yeni mra nso a yedidi me masem ene yedidi wo wasem ana mra foforo nso a yedidi maami Jane Mensa asem emra ne ye ba kope na Ghana ha mra bia ne ho abetimi ahye obi so omegina adakam no ni ho adanse ana wakwa akofa dan no epono na chi ana wo sai abasa wo case a wankasa wodi wano enye obi na kan no wo close wo case na wo se wadi wa agro nyina awie wa bo nkura awie no wo sa se court makwan na bie wa asem no na de kwanti a wo bie wa asem ne se wo pese court e de enhye ehye Madam Jane Mensa no begina dakam na toto na no court na asem o kan se ansa na obebi asem ani no na bia okuta dansidi bia dansidi na bra na wudi asem no ne yenya nhuye enye no nko a empokra dansidi no na ewo se wo kire mu se eyampa eyade na wo hwehwe na woni abre se wo hwe sa dansidi na won sanka na afi na won saka enye no nko a o sa dansidie ni adansidie mu odu ebetimi asachira eya asem na ye dinani dabi we de ensem amode ba court no enya dance de fufuro bia na emom asem amo kan se yemi asem nani na omuntimi san twe madam je mensa emba begina eye court anim eno na court ka se emra no enkyere saa na nya de obetimi aye nempo eno na ye gina he ye san kan asem ba ko se justice Olenu kan se bi se obi bia obekọ court a obegina obi asem so se wo de nipa no beka na asem ansa na wasem mu ayedu no na se nipa no na bia na wutrim ekawo enye me na me kan ye eye openi Jamfi versus Bedu ena ebiem Poku versus Poku eno so Supreme Court asem a se enye obi bia oye kwadwofo wa wo mpa adwuma wa wo no unwura mu ndomu asukọ se ne amra ne ka no na emomu ba court wani ha na wo ba na no wo se court ne mo da bi court no enya ade a court be saa eti court anu asem a wo de baaye no ene se emra bia ni hono ma be hye Mami Jane Mensa se wo ma begina adaka mu ne ya tete nsem ne bia nkofo ka se pepepe yonti sa asem no be da honti kama Mami Jane Mensa oba na nko begina adaka mu ana ye dey abusuafo ensam a oba pa Jane Mensa so ka nyina ne nyina ne wo ho okọ abafu mfidie so a yisi e wo ho ne nkrata ode aba court e wo ho ade kronti a Mami Jane Mensa wan nyina adaka mu ne se ye nuanom NDC fo ne petitioner no omentimi amfa danse a e ka fom a fom pai ama court. In fact, and someone back out court in Yano, and my yaya sama yakan crown, Ashamukina. Yaya sama yakan crown, more do. It in some yakan yana say, Omunia Samubakaya, near the kind amane, send some no crown, and Kakot any Kamungu, and I called said there be the Becca and someone, a yabotaya, and Untia Bahasen, who near Diafra. And Tiakran yedi kind atu, and Cradada, someone sama Modia Bacotono, a moha, a munyedu. And Tiabusia. And then somewhere Cosiano, Nina Jamraso. Na yaba kota, Sabi, enya Enkrobon Yababo, and enya Goodian Yababidi. Ayamra entina Yabahase. Adibia Yahabiano, Ayamra, Entinia Waha. Oh, bar for dance ya bra. Memanas and Mreyo, our wasemoa, who pese Wujina Obiso and a dear wasem. There be and no enya dear court, a bepene, a massa semno, a coso. Abusiafo nyamia aduma ochina anase na de chie ye besa chia na wo hwe ensam a court ebo ne tofa ne nyina na ne omo kan nyina ne se enya ade a court ebetimi ama kwan ama Madam Jane Mensa ababegina ho na central fo busa asem bi na emuye me de pa sanse NDC fo bi e ka se omo withdraw omo case en withdraw omo case no kra NDC fo kasa omo dika because wunya witness no betra da kam no kase krata ode ne sasha ase no eya opani rojo metonunu krata na mfumso no ye na isi che ne dada no wo si isi che esake no epamo no enso na adanse aba beda di se ukonum tea na biscuit ni amfa ma wo ni nyina no ye niema ebeda di enti NDC for kwam mfa wo serious opani kwasa white busa na wo si nipa aba bedi dwumadi kase sei wo si ufri fiaba no wo refi wo charger wo fie enti phone bedum ye enti nipa wo pay figures na fi no wo constituency regional level no nipa ne person ofra wa enkomo be no betimi wadi enti ye nuanom NDC for kwam paba e wa asem ni mu enu enti no ana omo ka tro mo nkofo se asem na be kwanka mo free court because mo am nkofo mbedi adanse kra no adanse di ombedi ye no emu eha opani esiedu nkatia obetra da kam yamani bu nkontana na nkontana kwakosi se na nado danko akufa adunya ohamu nchichemu aduonu ne ekirei enkota bi obu ye bia ekire saa enti esiden enene musa ba ebeka kire se agi se mumu case ni nyenti no mo de ahye mo krata mu se ehu be hia pa ma mumu case se na be mu case mbe edu agi se Mami Jane Mensa ma begina dakam ebusuafo ye nuanom NDC for any petitioners no omasem na nkasa no omadwen mu omatoagu enso bi eni agina mu nyame ya adomo a ye beba court biem court a chese obi amfa ne closing addresses aye ya wie no obi amfa na asem ngu krata so ne ensan emfamra nyame nhyira mu NDC case ne de atonsuom na senia dam ya no mesremo chairman Mark Menu aka yen chen e wa hase aka yen ho star witness on ejin mo mampani na nado danko akufuado ya mame lawyer Joyce Opoku Boateng so ha sei lawyer Faisal e wa ha lawyer Lennon enso e wa ha eye Hajia Fatimatu Abubakar eye lawyer papa ono so wa ha minister in charge of information designate ono amu nso SI eye lawyer Evans Nimakon ono in charge of elections ono nkuntabu e course ba nyina no ono na di animu lawyer Kiyamwa, Menusa lawyer Sean Su Ejinamechi, maybe lawyer Kutampao, lawyer Frank Davis, lawyer Yawopon, lawyer Adudapa, lawyer Kwekwe Sifi, lawyer